Good morning, ladies and gentlemen. What I would like to talk about today is what evolving European climate change policies essentially mean for Irish environmental law. I am interested to understand, I suppose, to what extent European policies in that area, and Irish policies, of which there are very many, whether they are materialising, if you like, into hard environmental law, into hard Irish law. And I am not being particularly prescriptive or specific about what environmental law is for those purposes. It certainly covers traditional pollution control, and so to what extent, if you like, is carbon dioxide and other greenhouse gases, to what extent are they controlled, and how in Ireland it can be taken to cover those newer areas for environmental law where relevant, like resource efficiency, and of course practices, rules, new rules, perhaps conventions mapped out for regulatory authorities, notably the EPA, that are driven by the climate change agenda. And that is an agenda which has emerged in response to a threat which is very much an environmental threat. Serious bodies like the IPCC consider that it's not a perceived threat, it's a real threat, and it's getting to the stage very quickly of being of catastrophic proportions in terms of risk and hazard and probability and so on. So really, what does the growing seriousness of that threat mean? Does it mean that the climate change agenda is evolving from sort of behavioural change into harder legal obligations and controls? And really, that's the essential question that I want to look at. And my starting point is that to say that I don't expect to see a lot in the way of hard Irish environmental law. And I'm making allowances for the fact that many of the areas and the sectors that are at the basis of this problem are not easily amenable to direct legal regulation and control. I expect to see that our social attitude in Ireland will, to some extent, to a large extent, inform our legal response. And in that regard, I think my impression is that socially in Ireland we are not really engaged with this problem. We engage in as much discourse about it as a lot of other countries, but that does not translate into results, it does not translate into leadership, it translates into just mediocrity and in terms of results and where we're going with this. As I hope to illustrate later on, I think we certainly are under the impression that it's not our problem. And if any of you were at the James Lovelock talk in UCD last week, the eminent independent scientist James Lovelock, he made the point very clearly that whereas we may not experience here in due course the worst effects of climate change directly, certainly he painted a pretty grim picture of Ireland along with New Zealand and a few other countries as a lifeboat country, and the very possibility even of that is a pretty serious matter. I think our ambivalent attitude here is also demonstrated by the fact that whereas historically we may not be responsible for much of the build-up of greenhouse gases, in the very face of the problem, it hasn't stopped us being, up to recently at least, the second highest emitter per capita of greenhouse gases in EU 27. So, and more generally, I think, I suppose I don't expect to see much in the way of hard environmental law here, simply because of a more constant issue, which is that all environmental laws, and the amount of them, are always highly imperfect. They're almost always highly imperfect because they are engaged in addressing environmental problems. To deal with those effectively, it is a constant that you are taking on economic interests, some very important economic interests, but there's always a trade-off. And so I expect to see the same in the area of laws addressed towards the climate change issue. But it's 2009, and it may be worth looking at it afresh, because it's the year in which the international community comes together to try and hammer out concrete post-Kyoto structures and targets and commitments. 2009 is the year also in which, well, separate from the protocol, but kind of in anticipation of it, the EU climate change agenda, the main targets of which don't kick in until 2013, nevertheless legally comes into operation in a couple of days in terms of the initial implementation of that. So that's what I would like to spend the next 15 or 17 minutes or so looking at. So there is a pretty rough diagrammatic of what the package, the EU climate energy package involves. It's essentially a package of targets, the yellow in the centre, and a package of legal measures, the green and the white, which relate to those targets and try to achieve them. The essential it's the 20-20-20 package, as it's called. Reduce greenhouse gases emissions by 20% by 2020, improve energy efficiency by 20% by 2020, and increase the share of renewables in final energy consumption to 20%. Also by 2020. And the four green directives, or three directives and one decision, are on the point of being implemented. They were proposed by the Commission back in January 2008, agreed by the Parliament and the Council, and it's just a formality now that they'll be published in the official journal in the next couple of days and will come into operation. There's a number of other background directives, the directive including aviation and the EU emissions trading scheme, a proposed directive on fuel efficiency and cars, that all feed into that process. But you will see that ultimately it's all heading up towards, directly and indirectly, towards the overall goal of reducing greenhouse gas emissions by 20% by the year 2020. So what I'm going to do is spend a few minutes looking at the four ones which are about. The directive on aviation is in force since last. That shouldn't be hatched. That's in force since last July. In any event, I'll just spend a few minutes looking at the context and some of the content of each of those four green directives and what it means in Irish environmental law terms. So I think the first one, the directive on carbon capture and storage, it makes sense to perhaps start with that, given its title. It's the one that seems to be most focused on getting to the heart of this problem. It's not called the directive on carbon capture and storage. It's called the directive on geological storage of carbon dioxide, setting a regulatory framework for that. I just want to look briefly on where we're at with CCS, what does the directive say, and what does it all mean for Irish environmental law. It's not a new technology. Obviously, it in a sense comprises three elements. The capture element at the power plant or the industrial emitter, it's capture, stripping out, transporting it by pipeline, injecting it into geological formations, and that latter aspect, the storage aspect, has been used quite effectively for some years in enhanced oil recovery, enhanced gas recovery, a simple process of where it's considered there's no real risk of leakage out of the geological formation, pumping in the CO2 to increase the yield of depleting oil and gas fields. And that's really where we're at with it in Ireland. It's from September 2008. It's an all-island assessment report by the SEI, the EPA, and the GSI of the Irish GSI and GSI of Northern Ireland. And really an assessment of the potential for geological storage of CO2 for the island of Ireland. And really, it's a very chunky report. Ultimately, it says that, subject to further analysis, the depleting Kinsale Head gas field may well prove very, very useful in terms of capturing all the emissions from, say, Moneypoint and a number of gas plants in the Cork area. And I don't know if there's any sort of veterans of Mullaghmore there, but certainly Moneypoint is mentioned a lot in the report, and as is once or twice the Burren limestone caves, if you do a word search for it, and many people will be alarmed to see the two of those appear in the same document in the context of carbon capture and storage, but I don't think there's any serious exploration of the Burren as a location for storage. Those two images, really, the one on the right is real, the one on the left is an impression. The one on the left is an impression. It's the Future Gen integrated gasification combined cycle plant in the US, and it The Department of Energy pulled the plug on that because the cost overruns last year. It's just not happening. I suppose it illustrates the difficulties there still are in commercialising and deploying all of this. Schwarze Pumpe in eastern Germany is the acme, if you like, of where CCS is in Europe at the moment. It's still at pilot stage, but it's working very, very effectively, and it's very, very promising. The Schleitner gas platform in the Norwegian North Sea, working very effectively, not just in enhanced gas recovery, but in terms of stripping out the carbon from the natural gas and pumping it back in. And that is attributed its success to the fact that Norway has a really, really hefty carbon tax, and that, therefore, it has become an economical process, an economical prospect. Kings North in the UK, where, in effect, the key issue here, one of the key issues, is between industry and government, who's going to fund this research and commercial deployment, and in what proportions. All that issue is being played out, as is the issue of whether there ought to be retrofitting conditions built into the planning permissions for these plants in the first place. So in a sense, the directive, very briefly, it just creates it jumps forward to the kind of storage regime at the back end and says, well, if you're not going anywhere with storage, if you can't find safe locations to store, then you're going nowhere. So that's the primary focus of it. It creates a regulatory framework, capture, transportation and storage. Then it amends a range of existing environmental legislation to kind of anticipate its deployment in due course. The regulatory framework for the storage envisages it envisages an upfront exploration permitting along the lines in which, commercial competition for industry to go out and explore suitable locations and be given concessions to do that and so on. The storage permitting, once a suitable site is assessed, it's exactly the kind of almost a replica, except much more detailed and much more stringent for IPPC licensing. The application supported by an EIS, upfront monitoring plan, corrective measures, and conditions, of course, detailed sets of conditions with the storage permit, all particular to CCS, if you like, injection pressure rates, the storage complexes, identifying them, in case there's leakage to ensure the hydraulic effects are still captured throughout the whole storage complex. CO2 stream quality, ensuring this isn't, waste along with CO2 or other non-CO2 materials aren't going to be stored. And because you're dealing with long-term storage, there's a particular focus on long-term monitoring post-closure. Additional features reflecting all of that are detailed provisions in there on transfer of responsibility to the state. The reality is, with an IPPC license at a end-of-life stage, you can anticipate that the licensee will, or a related company, be I suppose, in existence for some time afterwards, but in the lifetime of a CCS storage facility, you've got at some point to anticipate a formal handover to the state, and it's also there to incentivise, I suppose, to know that companies can at some point hand over to the state. There are extremely strict financial indemnity provisions and third-party access provisions that try to kind of achieve a balance between the people who spend the money up front on developing this technology, but recognising that in countries like Ireland you're not going to have too many storage facilities, therefore you're going to have to allow third-party access in the same way or along the lines of the gas networks and so on. Those are all in abbreviated form, the sort of environmental directives that need to be changed to reflect capture, transportation and storage. EIA to ensure storage facilities, pipes and all of that are subject to environmental impact assessment. The Water Framework Directive, relevant controls in there to ensure protection of groundwater. The waste one to things like, and the transfrontier shipment of waste regulation to ensure that the shipment of CO2 offshore is not considered to be a waste material for the purpose of that regulation. All of that, that's the kind of thing that's involved. I think the key one there is the Large Combustion Plant Directive, the LCP. I mean, that's really the one that gets at, is this going to be mandatory or not? In effect, it says that for all power plants, for all new power or large combustion plants, for which in effect planning permission or the operating license is granted after this directive comes into effect in a couple of days, the applicant or the operator shall carry out an upfront assessment and of the feasibility, of the possibility of storage sites, of the technical and economic feasibility of transportation, and the competent authority determines if those conditions are met, and if they are, then really the height of the obligation on the operator, and bear in mind this only applies to new power plants, so you may have to ask, where does it stand in relation to money point or something like that. The height of the obligation on the applicant is that they must set aside sufficient space at the new plant to enable a retrofitting, which may or may not occur in due course, depending on the... So it may be considered, given how elaborate a provision this directive is in anticipation of CCS, it seems to me that the ultimate retrofitting condition, if you can even call it that, because it doesn't even apply to existing plants, is quite weak, and I think there's plenty of room in there in terms of the test of technical and economic feasibility to ensure that we won't see much of this in operation for a long time. So I think the implications for Irish environmental law are just in terms of technical and consequential amendments really to those Irish implementing regulations that implement the EIA directive, the IPPC directive, and all of those will in due course have to have technical and consequential amendments to adapt the element of the directive I spoke about. I mean, other effects I think that will come down the line are whether we'll extend the Strategic Infrastructure Act to formally capture CCS in any shape or form of the storage facilities. Who will be the competent authority? I mean, a lot of these are going to be, if they're going to be in any, they will be offshore, so will there be a role for the Marine Institute? Advising the planning authorities, insofar as planning authorities have jurisdiction offshore, but increasingly they have in terms of renewables offshore and so on. The HSA, the Commission has considered, are storage facilities to be considered like Seveso directives? Is there a threat of a major accident? And that's an issue which hasn't been determined yet. Land use planning, in the same way that Seveso installations where large stores of, I suppose, combustible or explosive materials are held, and there's kind of sterilisation zones very often around the most dangerous sites, will there have to be? So planning authorities will have to kind of, if there are any in an area, will have to be cognizant of them in terms of land use planning and zoning and so on. And of course, all the international conventions so far, OSPAR and the London Convention on Dumping at Sea, have all sort of adapted protocols to permit CCS offshore in due course. Sorry, I didn't anticipate 15 minutes, so my talk is a bit longer than that, but I'll move as quickly as I can through it. Okay, so ultimately, whether it happens or not, I mean, the view apparently is that, and this makes economic sense, rational economic decisions will determine this. The cost of carbon, in other words, will it be economic or not to deploy CCS for any particular installation? And really the only kind of signal for the price of carbon that we have at the moment is the EU emissions trading scheme. And there is a directive revising the EU emissions trading scheme to, in effect, correct a lot of the weaknesses that are recognised in the scheme to date. It's not working. There is a graph of the price of carbon showing a height of 30 euros a tonne, a spot price, going back at the pilot phase of the scheme a couple of years ago. It's a cap and trade emissions trading scheme for carbon dioxide between the largest emitters, but it collapsed at the end of 2007 and has barely recovered since, and that graph goes up to December 2008. It has collapsed again since. The whole scheme was never recession proofed, for one thing. The allocations were considered and certainly were far too generous, and it is certainly not sending a strong price signal that will incentivise CCS. I think the Norwegian example and Sleipner is a good example of where we should be going. I mean, the directive revising it seeks to do a number of things. It's the third phase of the scheme, coinciding with whatever the post-Kyoto regime will be in place, is a longer eight-year trading period, more certainty. There are new sectors or gases in there. Aviation has already been included. Some smaller installations that shouldn't be in it in the first place, hospitals and small ones, just because they have backup boilers, are being emitted. The overall cap, for the purpose of the cap and trade scheme, I think the starting point will be, in effect, the Phase 2 allowances adjusted to reflect the Phase 3 inclusions and exclusions. The bottom line is that the overall cap will be about 11% lower than in Phase 2, which runs to 2012. And again, in light of the seriousness of the problem described earlier on, I just wonder if that is sending a very, very serious signal. The allocation of allowances, it is still very much a mix of allocation and auctioning, despite the fact that auctioning was meant to be the absolute principle of this piece of legislation. There are so many derogations and so on that in fact only about 50% will be auctioned of the allowances, and there'll still be an element of free allowances up until 2027, which is absolutely extraordinary, again given the seriousness of the problem that we're in. No more national allocation plans. The EU sets an EU 27-wide set of allocation rules to kind of avoid distortions of competition. There are some of the carbon leakage and some of the derogations that I mentioned earlier on. So I think the implications for Irish environmental law, again there will be some technical ones. The existing implementing regulations for the EU emissions trading scheme and its Kyoto linkage and all of that, those sets of 2004, 5 and 6 regulations will all have to be substantially adapted to the point where a completely new set is probably warranted. I think there'll certainly have to be some there will certainly be EPA activity and liaison on who the new industries are, who's out, who's in, and so on. And the EPA will certainly be conducting more auctions, the online auctions that they conduct. So really the implications are, I mean, none of this has changed anything. Carbon dioxide is still a gas that you can emit as much of it as you want, effectively, as long as you surrender allowances for. The model is still the same. The EPA issued in the US issued a very mischievous sort of announcement there recently where they said, in effect, well, this is sort of post-Bush and the sort of newly empowered EPA. Well, we are going to include carbon dioxide in the Clean Air Act, which was a very significant pronouncement because in effect said it is a pollutant and can be subject to. Everybody assumed that there will be a cap and trade scheme where again you can emit as much of carbon dioxide as you want. I'm making all due allowances here for the fact, of course, that we have very much an energy economy. It's not an easy gas to control. But I think the EPA were being mischievous, but it's a point of principle with them. But in all likelihood, you will have an EPA. So in effect, you know, the Environmental Liability Directive, I mean, that will be amended in due course in relation to this, and you will have your permit compliance defence under that. I'm going to move on briefly to the decision on effort sharing in the non-ETS sectors. This is the third piece of legislation I just want to cover briefly. Maybe 2 minutes. It applies to these non-sort of point sources, these non-large scale point sources of pollution, and requires a 10% reduction compared to 2005. It's called the effort sharing because there are individual country targets, whereas there's a EU 27-wide reduction target of 10%. Ireland has to get 20% below its 2005 levels, which is extraordinary. The individual country targets were set on the basis of GDP per capita in 2005, and of course Ireland had the highest in EU 27 at that stage. So it doesn't matter that we're now in recession. Well, it just shows, I suppose, how awfully our economy and our climate change efforts have been managed to the point where, despite being in recession, we're considered to be the best performing economy for the purpose of this decision in EU 27. Those are all the sectors that are going to be covered in it, and the directive suggests that taxation is something that member states can look at, and of course that's something we have been looking at here for many years. That is the National Climate Change Strategy. If you go to it, you will see that many of those kinds of measures, it's very much those programmatic incentive type measures, are all covered in the National Climate Change Strategy. I would ask the Chairperson for just a small minute or two just to wrap up. Thanks indeed. And the decision contains a whole series of rules about the extent to which Kyoto Protocol credits can be used to meet our targets, banking and borrowing between years. So there are some flexible mechanisms in there for the state to meet its 10% target in the non-EU ETS sectors. I'm going to move on to whether, I mean, is it environmental law terms? Is it an environmental law? Nominally, in the sense that it's kind of like a climate change law, in that the country has set mandatory targets for itself, or we have mandatory targets. In terms of potential for infringement proceedings against Ireland in this, I think they're real and appreciable. If you read the EPA report, Ireland's greenhouse gas emission projections 2008-2020, it's from March 2009, in effect what it says that the existing suite of policies that we have in place right now will leave Ireland substantially short. Additional planned measures up to 2020 under the Energy White Paper, the Energy Efficiency Action Plan that's in preparation, all of those measures will still leave us short. We can only hope to get anywhere near the target, and even then we'll still be a little bit short through the use of carbon sinks in Ireland, planting up to 8,000 hectares of forestry per annum, and that's not by any means clear that we'll be allowed by Europe to do that. So where's the balance going to get us over the line to meet our target? Obviously it's the Kyoto Protocol credits, but I think that is running directly counter to what the Minister said in his carbon budget speech last December, to the effect that long term we simply cannot be relying on these. But here, according to the EPA report, it doesn't mention Kyoto Protocol credits, but it does say that we will fall short, and I think it is a very serious matter that in 2009, 4 years before this target even kicks in, the EPA, based on our emissions projections up to 2020, it's pretty clear we're going to be falling short, even with all of the additional planned measures that are envisaged up to 2020. I'm going to skip the last element, the Directive on Renewable Energy. There's not a lot in there about hard environmental law in the first place. A lot of its measures are covered in the Energy White Paper, the Bioenergy Action Plan, the All-Island Grid Study, the public consultation on the biofuels obligation scheme that will be in place shortly, and in effect the directive on renewable energy, achieving 20%. Ireland's target, Ireland's individual country target is 16%, and I mean there are some graphs in there to perhaps show where Ireland is in all of that. You know, the directive in environmental law terms, the Directive on Renewable Energy really will be of relevance in the sense that planning and environmental law here will increasingly, as it is, being adapted to facilitate renewable energy infrastructure. Environmental law will certainly be called upon to control the environmental impact of renewables. One of the biggest environmental contentions in the last couple of years in Ireland involved a huge biogas and biodiesel plant, the biggest in Europe of its kind, proposed for a very, very sensitive rural environment with a whole range of extremely sensitive receptors, so that while they may help us to achieve our renewable energy targets, and they're absolutely necessary, it is a question of site selection and proper environmental impact assessment, and that's what those are the real environmental law implications of the Directive for Renewable Energy. So overall, in conclusion, making all due allowances again for the fact that many of these sectors and our activities are not easily amenable or not amenable at all to direct legal regulation and control. Insofar as the sectors are, I think the new measures are falling far short of what's required. In respect of an emissions trading scheme that is palpably failing to, it's being tweaked to the point where, you know, the cap is about a mere 11% lower than it was in the period 2008, or there will be in 2008-2012. And I've highlighted, in terms of carbon capture and storage, other weaknesses in there which I think fall far short of what's required given the seriousness of the issue we're dealing with. I mean, where to go from here? I mean, if you look at what options in the broadest terms are available to any society or any group of states in dealing with environmental issues, they'll fall into one of three categories. They'll fall into direct regulation, they will fall into taxation, or they will fall into cap and trade schemes. There'll always be one or the other, and ideally, of course, you will have a mix of both. Insofar as we have cap and trade schemes to deal with this climate change crisis, I don't think a great deal is going to change. We don't have a great deal of direct regulation. There are reasons for that, but there are reasons why we could have a lot stronger regulation. And in relation to taxation, The week before last, we were told by the Minister for Finance that he was awaiting the report of the Commission on Taxation in relation to a carbon tax. I came across an ESRI report that's 6 years old, where they considered the question of introducing a carbon tax in Ireland, and in a footnote they referred to the Minister for Finance of the day, talking about an absolute commitment to introduce a carbon tax by the end of that financial year, and that was 6 or 7 years ago. In that 6-year-old report, the ESRI told the government that yes, there would be competitive disadvantages vis-à-vis other member states in introducing a carbon tax, but set out a very clear pathway and a very clear signal as to how those competitive disadvantages could be mitigated and how they could be avoided. So, in absolute conclusion, I think that the EU climate energy package it's an out-and-out trade-off, and it's not going to get us anywhere near our targets. Thank you very much.